Good afternoon and welcome to the Hudson Institute. My name is Urška Petrocic and I'm a senior fellow at the Hudson Institute. And I will be your host today during this webinar that will focus on standards and technological leadership. So technological leadership is a term that we hear again and again in Washington, D.C., but also in other capitals in the world. And in most major nations are evaluating property rights are one of the main tools that the country has to encourage the type of investment in research and development that are needed to develop the state-of-the-art technologies that enable a company to become a global technological leader. And indeed, a strong system of intellectual property rights combined with the rule of law is what has enabled many of the Western companies to become global technological leader. Yet, a country's IP system does not work in a vacuum. Companies operate at the global level, and their ability to be fairly compensated for their inventions depends on their ability to enforce their intellectual property rights, both domestically and abroad. And in the past years, there have been several developments outside the United States that arguably affect the ability of US companies, but perhaps even Western companies more broadly, to compete for technological leadership. In particular, last year, the European Commission unveiled a massive regulatory regime outlining conditions for the licensing and litigation of patents that cover standardized technologies, or the so-called standard essential patents in the patent lingo. And since the regulation was first released, it has been criticized by several commentators, including judges, the European Patent Office, academics, but also US senators and formal public officials. And all these commentators have raised concerns with the effect that the regulation will have on Western technological leadership. Yet, last month, the European Parliament's Committee on Legal Affairs approved the regulation, and a plenary vote is scheduled for later this month. So to understand better the concern with this regulation, we have with us a terrific panel of speakers. We have with us Judge Michel, former Chief Judge at the United States Court of Appeals for the Federal Circuit. We have Chris Hannon, patent attorney at the Office of Policy and International Affairs of the U.S. Patent and Trademark Office. We have Eva Hakoranta, Chief Licensing Officer at InterDigital, and Rupert Bonnet, President and CEO at Fractus. Welcome, everyone, and thank you for being here. So, Judge Michel, let me start with you. You have been following the developments in Europe, and I know you have voiced some concerns with the proposed regulation. Could you explain a little bit your view?
Certainly happy to do that, Urška, and happy to be part of this panel. I guess I have 8 principal objections to the proposal that is moving forward in the European Parliament. First, there's been no documented problem that requires a major solution, such as this. It is asserted that standard essential patent licensing has created problems for small and emerging companies, but there's no track record referred to of evidence of this. And the consensus, on the contrary, is that the voluntary licensing system globally has worked very well for many, many years, really for decades. So the first problem I have is this is a radical solution for a non-problem. Secondly, the essence of the patent right is the right to exclude others from using your technology without your permission, usually in the form of a license for which royalties are paid. The proposal, if and when it becomes operable, will diminish the right, delay its enforcement, reduce the leverage that the patent owners have secured by getting the patent, and it, as we all would have to agree, greatly shifts the balance of power in favor of the implementers. So that's my second problem. The third problem is it is an interference, a compromise, really, of the rule of law that has worked well, and that ultimately is the foundation of civilized commercial interactions. So instead of courts being able to enforce a legal right, bureaucrats in an agency are going to intervene and at least delay, if not compromise, the outcome. Fourth, the methodology previewed involves counting all the relevant patents as if they're all equal. But it is an axiom of patent law that the commercial value and breadth of scope of patents varies enormously. And therefore, counting them all as equal is an irrational and counterproductive approach. Fifth, another methodological problem is the procedure assumes that the total royalty amount can be set rationally by some government agency and then subdivided among all the SEP patent owners. But the premise is wrong. There is no sensible way to decide a total royalty burden. So it'll end up being quite arbitrary. Next, the agency tasked with enforcing this regime has no expertise or experience in determining patent scope, much less commercial value of SEP patents. It seems to me clear that market value as known by those in the industry should continue to be the standard, not some arbitrary or ideological view of some government official. And, you know, the suspicion I cannot resist is that this, the move in energizing this proposal is not really from small entities. I suspect, I have no proof, I admit, I suspect it's from the huge automakers who want to have total connectivity of communications of many sorts between the cars they make and everything else. And they don't want to pay substantial royalties for that. They want to get it for free or at least at depressed rates compared to the past. So I think that's the real force behind this, which makes the proposal even worse. And of course, as we will no doubt reach in our discussion, lurking in the background is China, which is trying to strangle the rights of SEP patent holders in order to lower the licensing burden of their own domestic implementing companies. So we have a global chaos facing us, and it's going to be made worse by this European proposal. I'll stop there.
Thank you, Judge. Very, very clear. Eva, let me turn to you. InterDigital is one of the few US companies that continue to contribute to the development of technological standards in key areas such as advanced telecommunication. What is your view on the regulation? How do you think the regulation will affect your ability to compete at the global level?
Thank you, Urška, and let me also, say that I'm very pleased to be here with all of you. And I would start by saying that, this draft regulation, if it becomes European law, will give the upper hand to implementers outside the EU. It's difficult to understand why the European Commission would propose a regulation which goes against the interests of its own innovators and benefits only players in other jurisdictions. And, building on what Judge Michel already mentioned, especially in China. And that comment really for me, comes from a quick look at, where are we at InterDigital currently having most of our unlicensed implementers. And those are in China. And they are very powerful, big, large corporations who will benefit from devaluing the standard essential technologies. So it's going to make, it much more difficult for us to compete in the international market and it's a good question how licensing will continue to happen if this becomes law, because as I look at the market, it's a global market, and patent licensors are offering a product which essentially means a legal right to exclude. So your ability to go to a court in a competent jurisdiction is really the only leverage you have. And if the Commission is now, the European courts, the real problem in the market is holdout in SCP licensing. Holdout means the ability of large, powerful implementers to delay or refuse to pay any royalties while they are using patented standard essential technology. And that has been encouraged by the fact that there has not been any international dispute resolution mechanism. We do have arbitration, but arbitration requires the consent of both parties. And now we have European courts leading the way to trying to mitigate or address holdout. And the Commission seems intent to stop those European courts and deny access to them, or at least delay access to them for at least 12 months or whatever. And I think the problem I have with all of this is that it is completely detached from the reality of licensing of standard essential patents. And I am asking myself the question that, the people who drafted this and the people who planned this, have they ever been negotiating a license with a large, powerful implementer? And I bet none of them have. Let me stop there.
Thank you. Yeah, very important practical perspective. Let me go to Ruben. A question for you. Fractus is an European company. How do you look at the regulation? How do you think the regulation will affect the ability of European companies to innovate and compete in the global market?
Well, hey everybody, and thank you for the invitation to be in that fantastic event. If I may, as I am a little company, let me introduce my company a little bit for the audience. We are an SME from Europe, innovative SME. We are in the antenna field. We are in Barcelona, and we have been born as a spin-off from a university research center in 1999. So we have licensed our technology globally into the mobile phone industry, but also to the network telecom infrastructure. And today we are focused on the IoT industry. We have many awards, and we have a number of licenses worldwide of big corporations. In the past, Fractus was a product-based company, so we were not doing licensing. But because of the copying that we had on our technology, we have no other choice, and it was in fact the movement that we made to change from product to licensing. Okay, so we created the technology in Barcelona, and we invested, and this is important, and I want to discuss that, a lot of time, effort, and money into R&D, funded by public institutions in Spain and in Europe, but also private money coming basically from venture capital, which has been instrumental in the development of Fractus technology, as many others, SMEs and startups that are today in Europe. So we have been litigating our patents in the US. We have done this several times. And the reason why is that in Europe, being a European company in Europe, before the implementation of the unitary patent was a fragmented market, so it was not an option for us to enforce our patents in Europe. So that's the reason why we went to the US. So let me also clarify that Fractus patents are not standard essential patents. However, everything that impacts on the patent system is going to impact impact us. So we are very, very concerned on the implementation of that regulation. And for us, this is an unnecessary political intervention to a problem that, as Judge Michel has said, does not exist. So there is not evidence that we have a problem. So we have to solve it. And I don't want to repeat the arguments that the other speakers have said. Let me go to maybe a different angle, which is that in Europe, we have been debating for many years the implementation of the unitary patent, which is at the end to make the patent system stronger, right? And to give more power to the judges to help in those licensing negotiations to become, to become a business, become licensing. So this regulation, it's completely out of the scope of this trend in Europe, which is to enforce patent system, to strengthen the patent system. It goes in the opposite direction. So I am not only concerned, but to some extent, it's difficult for an SME to understand, involving patent licensing, to understand what is going on. There is another element that I would like to share some different points of view, which is that in all this debate, it seems that to some extent, implementers and developers, to put the two categories of participants here, are to some extent put it at the same level, right? So you have a patent, you want to license the patents, and then it's the same level, but it is not. So the developers has been investing millions of euros and dollars in R&D, in activities, in planning the budget, in recruiting engineers, in making prototypes, in testing the system. So this is a huge investment, right? And this is being done before the patents becomes granted, right? So this narrative of equalizing or putting at the same level implementers and developers, it's simply not true. This is not true, right? So the investment in R&D happens before. And maybe just to answer your specific question, Urska, which is, well, what is the impact of this to the European companies, right? So to compete in the global marketplace. Okay, so let's say that I don't have a proof, but for implementers, European implementers, to compete in the global marketplace with or without this legislation will not change. I don't think it will change. I mean, implementers has other ways to compete into the marketplace, right? Not this particular regulation at all. But the European developers, if that legislation becomes valid, will be severely affected, right? So there is going to be less investment in R&D. There is going to be less effort putting into standardization, which is the contrary to the spirit of European companies, right? So at the end, if this is put in place, it will not impact the implementers at all, in my opinion, but it will impact very negatively the developers. And I stop here.
Thank you. Yeah, very good point. Not only it's the regulation solving a problem that does not exist, but can have very severe unintended consequences for investment in R&D, as we heard in Europe and in the United States. Chris, let me turn to you. Very quickly, how is the USPTO looking at these developments in Europe?
Well, thank you for the question, Urska, and thank you for the invitation to be here with everyone. So we've been closely following the developments within the European Union since this proposal was first introduced. So we actually have a IP attaché located in Brussels. So that team, as well as many at the headquarters in Alexandria, work closely monitoring this development. And as was mentioned, the progression it's made so far through the jury committee and the next vote for moving it toward the trilogue process. And since it was first introduced, we at the PTO have really been reviewing its merit on substance, as well as collecting stakeholder feedback from all of our US stakeholders. And so perhaps it won't come as a surprise then that stakeholder opinions are largely split. I would define it as sort of the net licensees versus the net licensors. And so from that, I think the commonality, at least, that emerged early on was that no one was completely satisfied with the proposal as it was originally introduced. So the net licensees didn't think it went far enough, whereas the net licensors saw it as unnecessary regulatory burden. So I think for the USPTO provided these international implications, as we've heard from Judge Michel and Eva and Ruben, that any sort of regulatory proposal that will necessarily affect the licensing of what is a global scheme for patents, right, across the world with portfolios. I think we're, at the PTO at least, encouraged by the ample discussion that events like this event today to really discuss the potential effects that this regulation could have, so that we can make sure that policymakers in the European Union understand all of the effects of the regulation, so that they're understood and appreciated, so that any amendments that need to be made or the vitality of the proposal at large is really well considered. So we're continuing to monitor it and staying engaged with our colleagues abroad.
Thank you. And a quick follow-up question. Only a few months ago, the USPTO, together with other agencies, requested public comments on standards, the technological leadership, including the question whether intellectual property rights and policies of foreign jurisdiction threaten U.S. leadership in international standard settings. And I had a look at those comments, and virtually all comments pointed to the EU SCP regulation. What did the USPTO learn from those comments?
Okay, thanks for the question. Yeah, so just to take a step back, I think that endeavor was really tied to part of the Biden administration's push for a US government national standard strategy around critical and emerging technology. So that particular strategy that was unveiled in May of last year set forth 4 objectives that we as the US should be looking at. And that is, how do you ensure that there's enough investment around standards, make sure that there's participation, encourage that we have this next generation of a workforce that can participate, but also, fourthly, make sure that the integrity and inclusivity that is set forth for these standards bodies is actually robust enough. And so as part of the participation prong, that's really where the USPTO had a larger equity. So we decided to set out among some of the commerce bureaus, the International Trade Administration, NIST, and the PTO, to solicit comments around the impacts of foreign policies in this space. And so, of course, as Urska mentions, one of the top items of discussion in public comments was really the regulatory proposal being proposed in the European Union. But at the same time, there is a number of other endeavors going around the world right now. And so I think even the US's own strategy to implement those 4 pillars in a plan here is also something that I think foreign policymakers abroad are probably watching us for that same idea. So we did receive a number of responses, as you mentioned, about this particular proposal in the EU. And I think one of the main themes was that there was a concern about the precedential effect that implementing that regulation could have on the global standards ecosystem. So that is, if they move forward with their proposal, what's to say that that effect will not then sort of reverberate around the world, and other jurisdictions will feel the need to compel special rules for standard essential patent enforcement. So I think that was a major theme that we heard from those comments. But at the same time, there was also many others that sort of lauded the proposal's goal of transparency. So having more data out there, having more window into what comparable licenses are, or what patents are actually essential. There was a value that we had heard from stakeholders in that. But even those that were speaking of transparency, I think there was a segment that split over whether or not the cost to implement such transparency mechanisms would outweigh the benefits of that would actually outweigh the cost of doing so. And so I think that's a debatable point as well, in terms of how do you do that at such a point that the cost is low enough so that you're actually getting the maximal benefit of that transparency. So I defer to operating companies on the panel here to sort of give some take on that. But we also saw that there was a common theme that emerged, that there was a divide over the allocation of the sort of the efforts that would have to be put in place, or the costs that would have to be borne in implementing such a proposal, so that there was a notion that there was a perceived imbalance among the obligations that net licensors would actually have to undertake versus net licensees in regards to that. So that process of collecting all of that stakeholder feedback is really helpful as we, as the United States, continue to develop our implementation plan for this strategy around critical and emerging technologies. So I'll leave it there.
Thank you. Eva, a question for you. I know that you were looking into this cost benefits analysis and who will the regulation actually help. Do you want to comment on Chris's remark on the cost and benefits of the regulation?
Yes, thank you. Frankly, I have to say that, representing a SEP holder, who sort of, earns pretty much all of our earnings from patent licensing and invests it back, to standard-based research and innovation. I cannot see anything positive in this EU proposal. It is just simply, as Judge Michel mentioned, an over-regulation creating the problem that it wants to resolve. The Commission has done some cost-benefit analysis in its proposal. I cannot say that I fully understand it, but when I look at it, it seems to me that it's just a very simple transition of tens of millions of dollars or euros per patent holder from the patent holder's pocket to the implementer's pocket. So the really good question we should all ask ourselves is, who are these implementers who are going to benefit from this? Because a lot of the narrative has been about European SMEs and SMEs who need help with dealing with these massive SEP issues. And I mean, the Commission is sort of calculating itself that the cost per SEP holder per year is roughly 54 million euros, and the benefit for implementer is 24 million. I don't know how they do this exactly, but it seems quite unfair to me, frankly, that they are thinking that they create this regulation and they fund it by sort of imposing mandatory registration obligations, essentiality check obligations, and a number of other obligations to patent holders, and deny them access to European community courts while doing this. It's just unheard of. And I have to say that as a European, I am actually ashamed, of what's happening in Europe, because this is complete nonsense. This is complete madness. So there's a lot more I can say and I want to say, but, let me, stop here and let others chime in.
Erska, if I can add a note of history, there was a time when licenses were voluntarily taken quickly by almost all implementers. That time has long since passed because large implementers learned that they could stall out the patent owners, because if they don't quickly license at a reasonable market-based rate, they continue to use the technology without cost, and they put off ever having to pay a cost. So somebody got a patent after doing all the research, expecting to get licensing fees from a valid patent that is being practiced. And instead, they don't get the licensing fees because of the holdout by the implementers. So they've perfected this strategy so that they already are highly advantaged compared to the patent owner. So now the European government is going to give them even double advantage by delaying access to the courts. To me, it's completely crazy. They should be making access to enforce legal rights in courts faster and easier, not delaying it and making it more expensive. This regulation is totally backwards.
And if I can build on that, Erska, I'm sorry for hijacking.
Absolutely, please.
Because, and they're doing this, right when the Unified Patent Court finally sort of is taking its first steps and, would like to probably chime in and, have a say in how they view, standard essential patent disputes. And I have to mention also that even, Chief Judge Klaus Grabinski has, expressed serious concern with, access to justice elements in this proposal. Yet, the European Commission has put this forward, and we have to understand that now it's taking its, taking its, route forward in the Jury Committee and, the Council and the Parliament. Really, the European Commission should take a step back and withdraw this proposal and think it through again. They are the only party that can do that. Otherwise, we are going to get something, some sort of, amended mess, which is going to sort of, disrupt and destroy a lot of innovative industry in Europe and elsewhere.
Thank you. Ruben, let me ask you one question. So one of the stated justification for this regulation is the argument that, this is needed to help SMEs. SMEs have problems in licensing standardized technologies. So you practice as SMEs, do you share these concerns? Do you think that the regulation will help SMEs?
Not at all, just the opposite. So the big problem for SMEs trying to license patents is holdout. Okay, it's you made the R&D effort, you have the patents, and then to be able to capture the fair value for your invention, it takes a number of years, and you are facing big implementers that are big corporations that are using all legal means to introduce a number of years just to make sure that this little SME or big SME doesn't have the resources and the capabilities to go through all the process to license the patents, which is very problematic. So in the SME discussion, there is something very interesting that I was, I mean, when you look at the own documents from the Commission to justify why they believe that this is good for SMEs, they tend to rely on one single data or on one data, which is that SMEs are not really participants of the SAP licensing, patents, right? They are not members of ETSI and things like that, and they are saying that even they are the number of participants on the ETSI processes, it's very low. But by the contrary, this is what the Commission said, okay? But the contrary, there are a big number of SMEs that are implementers, right? That will be beneficial to some extent by shifting, this patent right from developers to implementers, which is what is happening. And this really, it's in contradiction with my own perception of the reality, which is that the empirical evidence shows that the SAP litigation involving SMEs is very rare. It happens very rarely. The second one is that there is also evidence that the SMEs that does not need really an SAP license from the implementer's perspective. So, discussions between developers and implementers go at a different level, not the SMEs. So SMEs are really participating here. And this idea of the SMEs are not members, let's say, members of the development ecosystem, this is wrong, because even though the statistics can justify that the SMEs are not participants on the standardization process, the SMEs and the startups that are SMEs and the scale-ups that are SMEs and the research centers are feeding constantly innovations to the system, particularly in Europe. So Europe is a great place for innovative startups and scale-ups, and those innovations are feeding the system, and then there are processes why the venture capital invest on those companies. Also, the implementers finally, through the M&A or acquisitions of small companies, gets the technology from the SME, which is not participant, but becomes a participant. So to some extent, the point that I want to make is that this regulation is for SMEs is based on the perception that SMEs are not participating in the development of technologies, and this is wrong. This is not true. So SMEs in Europe particularly are strong participants, and if this regulation becomes in place, I have to say that I will see a decrease in venture capital investment. Developed technologies will be much more difficult, and less money will flow to the SMEs that wants to innovate. That, to my understanding, it's a particular niche of companies that the European Commission wants to protect. But this is not the case with that regulation at all.
Can I chime in on this?
Sure.
So, because I've been also speaking with, friends and colleagues who represent SMEs, and, for instance, somebody in Taktotech that makes sort of electric films for the auto industry, and, it's an innovative company, and then, a sort of some others, and they are very concerned because they are concerned that their ability to actually sort of protect their patented innovation is going to be negatively impacted, by this regulation. It seems to me that the Commission has been mainly thinking about manufacturing SMEs, implementers who want to use, standardized technologies with, as little cost as possible. This regulation is so one-sided. It does not protect, the innovative industry. It seems to protect the manufacturing industry. And, really, I agree with Judge Michel's speculation that, behind this, in the political scenes, there very obviously is, the European automotive industry, which is, going through an existential fight as, the Chinese automakers are going to sort of start invading Europe with their potentially even higher quality e-vehicles. And, they are, really trying to sort of manage integrating wireless technologies and video technologies at minimal cost. They're not very open about it, but when you look at, Fair Standards Alliance and the more recent, social media postings that the Fair Standards Alliance has done, they've done a complete campaign. It's all about SMEs, and how unfair SCP licensing is, and how sort of, how terrible the technology developers are. When we look at what Breton said when this was published, he said he takes aim at bad faith patent licensors. And he said that he will bust de facto monopolies and prevent licensors from abusing judicial systems to maintain their dominance. So I think there is a huge misconception, within the Commission. They think that the companies that have invested decades into these standardized technologies and have sort of reinvested their licensing revenue in developing further technologies and contributed them to open standards, the Commission is calling them abusers of judicial systems. So that's really, what this is. And it is obviously to try and protect European manufacturing industry. And I think this is a terrible strategy for Europe, because Europe is not going to be the winner in sort of the cost of labor. They are not, we don't have the lowest cost of labor. So if Europe is banking on this industrial strategy, then, I think the German and the French car industry workers and everybody there has to, they have to start understanding that their wages, their salaries have to drop to the levels of their Asian competitors. I mean, that's what this is not about SMEs, even though all the pro arguments are sort of masked into SMEs. This is really about the global technology competition. And I, as a European, think that Europe is about to make a huge, massive mistake. which is going to wipe Europe right off this technology competition.
You know, Erska, if there are individual cases of abuse of legal rights, courts are not helpless to prevent that and punish that. They've been doing it everywhere for decades and decades and decades. And secondly, if there are dominance problems, that's the right subject for antitrust type action, not to devalue patents. So this proposal can't be justified, in my opinion, on the basis of assumed or alleged abuses, because there are already solutions at those two levels for whatever abuses may arise. So there's absolutely no need for this regulation.
And a little bit in relation to this point, I have a question, follow-up question, both for you, Eva, but also for you, Judge Michel. Many commentators have voiced concerns with the signal that this EU regulatory intervention would send to engage in price regulation for standardized technologies. So highly innovative products, a lot of R&D, and will this regulation be perceived as a green light to engage in price regulation of these technologies? Do you share these concerns? Do you think they're unjustified, or are they justified?
You know, if I start, you know, I definitely think that this, you know, is indeed a form of price regulation. I've sort of, you know, spent some time reading the article that Justus Barron from Northwestern University has written about, especially the mechanism for determination of reasonable aggregate royalties. And I think that's really recommended reading for anybody who wants to understand how this potentially works, because, you know, this only has the potential of driving the value down. It cannot ever, you know, take it up. So, you know, that's the mechanism. That is what they have put forward. It is a down ratcheting mechanism. And if this gets implemented, at least that part should be cleared away, because it is a clear price regulation. And it is quite sort of, you know, Europe, the European Union, it's built on sort of respecting free competition. And to see that the Commission now, you know, due to political pressures, is putting out a regulation which is really sort of aimed at regulating prices by the Commission itself, is quite ironic in my view. And I don't know, you know, maybe I should let Judge Michel chime in as well. I can continue.
Well, I would just add to Eva's point that we don't have to speculate about whether other nations, particularly China, will take refuge in what the Union is proposing. They already have been doing it. So it's a known fact. It's not speculation about a future possibility, and it will continue to work against all European and US companies that innovate, because the goal of the Chinese government is to lower the royalty burden on domestic Chinese manufacturers of a whole range of technology products. That's clearly what they're going to do, and they'll do it even more because they can now cite the European initiative as saying this kind of approach is justified. Look, they're doing it in Europe. You can't criticize us. They're doing it in Europe. And even in the US now, there are proposals of many sorts. We don't have time to go into them all, but that likewise shrink patent rights and patent values. If you depress patent values, you will get way less innovation across the globe. Full stop.
And I'd like to chime in that, you know, I fully agree. China is already reaching out to sort of, you know, grab pricing of standard essential technologies. And we have the most recent, Chinese Chongqing court decision in the Oppo versus Nokia case, which is quite sort of, appalling. I've obviously only read a translation, but, I'm very concerned having read that translation. It's a very one-sided decision. It doesn't even explain what Nokia's position was. It sort of goes directly, into sort of, regulating the pricing. And instead of, setting a global price, it actually sort of, sets two different prices. And very conveniently, it sort of, puts China in the lower bucket of sort of undeveloped countries. So that is already happening. So we are already seeing that, there is sort of a trend of fragmenting the global licensing of standard essential technologies. And I do want to mention as well that, one of the most recent developments, I think, is in US, and that is a letter that Senator Cotton has sent to Secretary of State Anthony Blinken and, Secretary of Commerce Gina Raimondo, urging them to do, maybe I should even quote, to employ the full range of legal and administrative tools to counter China's efforts to undermine pricing and standards for these technologies. And he goes on to say that without US intervention, the Chinese government will gain control of the worldwide licensing of wireless communications and other standardized technologies. And Chinese control would undermine US national security and threaten America's ability to continue leading the development of the next generation of wireless and video technology. I think this is, seems to suggest that, US is also sort of marching in. So while I think that what happened in US was USPTO and NIST and others, just, took a step back and, said that we want industry to regulate this global space because that's the best solution. And I do think that that is the best solution. And I have to say that, that's what I think the Western governments should recommend. And they should also try to encourage the parties to use international arbitration as a dispute resolution rather than, create regional dispute resolution mechanisms, which are going to fragment the system.
And I have just a follow-up question for Chris. You mentioned Oppo v Nokia, and my understanding is that in that decision, the court relied on patent counting to determine the value of the patent portfolio. And Chris, several years ago, the USPTO looked at the increasing number of patents in China and looked at their bond in this report.
That's so this idea of just rote patent counting and sort of alluding to a point that Judge Michelle earlier made about, what is the value of any one patent? These things will vary. And so when we saw the high volume trend in China back in January of 2021, the USPTO actually released a report titled Trademarks and Patents in China, the Impact of Non-Market Factors on Filing Trends and IP Systems. And so the report effectively looks at two particular policies of the Chinese government relating to both subsidies and these government mandates for patent filing volumes. And so noteworthy, like this was back when the report was authored. I know that the Chinese policies have since shifted, but effectively the result of that study at the time was that people respond to incentives, not surprising, right? So the fact that you have this mandate to meet a particular quarterly quota for filing, coupled with the fact that you had the ability to recoup or maybe even profit from the subsidies that were being offered, really drove patenting behavior in China. And so the study at that time looked at the correlation between the patents that were being filed in China to see if they were also, those inventions were filed abroad, because obviously if you have a really valuable invention, you're going to seek protection around the world, right? There's no such thing as a worldwide patent. But what the study showed is that there's not actually that corollary behavior from that volume of Chinese filings at the time. Those patents were really just, sought in China and nowhere else internationally. So that was, suggestive of a conclusion that there may have been less value associated with those inventions. And so that was one of two studies that I think sort of shed some light on the value of just characterizing every patent as equal. We also did another study in 22, so February of 2022, we released a report that was maybe more tied into the standards realm, looking at 5G. So that report entitled Patenting Activity by Companies Developing 5G. And there, we at the PTO were sensitive to this sort of chest puffery going around that was, company X is now quote unquote winning 5G because we have so many patents, right? And so we didn't necessarily think that that was a fair look at that data. Just because you have some volume of patents doesn't necessarily mean that you are somehow better than any other person. And so we wanted to take a look at the sort of the competition in that specific space of cellular communications, the fifth generation thereof. And so we did this a number of ways. We looked at data sort of from a triadic approach, which was indicating what patents are sought for patents or inventions in jurisdictions, notably the USPTO, the EPO, the European Patent Office, and the Japan Patent Office. And so again, going to that notion that if you are actually sitting on a really valuable invention, you're going to seek protection in some of the major patent offices around the world. So we looked at where are they filing, and so we could determine some conclusion from that. But also because 5G is such a fabric of many different technologies, it's not just some static technology, right? There's many components that go toward a cellular communication standard. We looked at which particular classes are these people, these companies filing into. And so certain companies are more active in particular spectrum of technology than another. And so you saw some divergence amongst where folks were filing for amongst those technological fields. But also, finally, there was a good set of sort of existing economic attributes of patent data. For example, how frequently is a patent cited, looking back. And so you could draw some sort of hints of value from that sort of economic attributes. So we looked at those as well that sort of pre-existed. And all in all, we came away with, there are some companies that have a larger volume of patents, but when on balance, you look at it within the lens of all these different criteria, you can see that there is actually robust competition amongst those companies developing 5G. So I think that gives some rebuttal to this notion of, well, hey, we've got the most patents, therefore we quote unquote won. That's not really telling the whole picture. And so I think policymakers need to be cognizant of that as they think about just, looking to say, well, because you have so many patents, they're all equal value. Yes, that's maybe an easy methodological approach, but it's not really capturing the true essence of what is being sought for a patent.
Yeah, thank you. Very, very clear that not all patents are equal in value. I know we are running out of time, but so maybe just returning back to the EU regulation and to our main topic of today's discussion, technological leadership. It seems to me that there is a general agreement that the EU regulation is not a move in the right direction. So in a more positive note, what are the right policies to create an environment where companies can compete on a level playing field for global technological leadership? What are the policies that will encourage investment in R&D in the US, in Europe, and other countries? Judge Michel or Ruben, any comments?
Ruben, why don't you go first?
Yeah, I mean, it's clear to me. So protecting innovative companies, Eva has made a clear point on whether we wanted to put the effort on manufacturing, which means labor cost or high value added jobs. And from the European and US perspective, it looks to me that we go for the second, right? So that means protecting innovation, not weakening the patent system, just the opposite, strengthening the patent system, which at the end will turn into innovations and progress of humanity, right? Which is what we want to say. Let me add something before we get finished on that, on the number of patents, right? So regarding the SME, so if this becomes implemented and therefore there is a strategy to file for more patents just to have more patents, to put it in the basket, this is going to be against the SMEs, okay? Because SMEs typically does not have a lot of budget to make a lot of patents. They have 1 or 2 patents, but these 1 or 2 patents are really good, right? You cannot compare 1 or 2 patents really good with a massive amount of patents that are really good, right? So that's something important for SMEs. But yes, I mean, protecting innovation and making the patent system stronger, not weaker.
Eva, I'd like to raise the issue of what I'll call relative competence. Who is better at valuing technology that has been patented, as between government bureaucrats, judges, and the market players? And I would suggest that it's very clear that it's not judges and it's not government bureaucrats. The people who really have the information and the perspective, the experience to make sensible valuations are the people in the industry. So the key to having the system work better is remove obstacles that delay the grant of injunctions against people who are implementing patents without paying. So this move is exactly in the wrong direction. We should be making access to the courts faster and easier, because the courts in most cases, at least in Europe, fortunately, less so in the US, but at least in Europe, is the judges issue injunctions. What happens then? The parties settle, because it makes economic sense for them to work out a compromise between the value sought by the one and the value willing to be paid by the other. That's the best way, because it's the most accurate way. Why should we choose a known inaccurate way of valuing IP rights?
I couldn't agree more, Judge Michel. I think I fully agree with you, and I also wholeheartedly, would like to see sort of recommending using WIPO mediation and international arbitration. We have a host of sort of very good institutional arbitration institutions that have high quality arbitrators who are, quite capable of sort of, resolving commercial disputes, because that's what these disputes are in the end. They are commercial disputes. And I want to add one element into this sort of, what would be the right policy. The problems that implementer SMEs are sort of encountering, there are much better, ways to address those problems. And if the EU sort of would really want to resolve those problems, it would have already, created an office, which provides easy access, and sort of information and sort of help for implementer SMEs, to understand how they navigate, in licensing standard essential patents. But the SMEs are really not the focus here. It is something completely different. And, I do think that, we could have some advisory, for SMEs, and we could even, create some sort of a regime, for SMEs. I'm pretty sure the industry would probably work, out something like that. But this is really a step in the wrong direction. And unfortunately, I think that, it can be very, very detrimental for Europe. The patent holders will find a way. The litigation will go somewhere else, if Europe's not going to be accessible. China is crying to get the litigation so that it can start sort of controlling the pricing. And somehow it's lost on the European Commission.
Thank you. I think we have slowly come to the end of our event. I just want to make sure, does anyone have any last comments, remarks? If not, then I would like to thank our participants. This has been a terrific discussion, very interesting. I've learned a lot, and thank you for being here with us.